Hey, everybody. Wendy Sellers here, the HR lady. I am here with my co-host, JC.
Wendy Sellers, the HR lady. It's my pleasure to be back. Ladies and gentlemen, tuning in today. If you are listening to us on Podcast Radio US in Detroit on 93.5 FM or 94.7 HD2, feel free to reach out. Let us know. If you're in Tampa, listening on 1010 WHFS AM or Charlotte on 94.7 FM or WSOC HD3. Feel free to drop a line over to Wendy Sellers so we know where you are. And down in Fort Myers, Naples on 96.5 FM, 101.5 FM, 105.1 FM, and WXKB HD2. We welcome you as well. Wendy, back to you.
Whoa, that was a mouthful. Thanks, JC. Hey, I want to talk about prevention today. We have a super awesome, amazing guest here, David Miklas, who is an employment attorney right here in my state of Florida. Hey, David, how you doing?
Hey, Wendy. Great to see you guys again.
Yeah, you too. Great to see you and hear you, I guess, for our listeners. But let's talk about, prevention. Prevention is always an investment. What are the 3 common mistakes that businesses make that lead to costly lawsuits?
Well, I think one of the key things is it's focusing on a cost rather than an investment. And one of the things that I see as a costly mistake is when a business owner neglects to consult with an HR professional or an employment lawyer, for instance, misclassifying employees as exempt from the Fair Labor Standards Act, the FLSA, or when they classify them as an independent contractor without actually looking at the 6-factor test that's used by the government. Both those things could be a legal minefield. Many business owners assume that simply paying a salary means they don't have to pay overtime. And you and I both know that's not what the law says.
Right.
That's the easy part of the test. There's other parts of the test, and that's what you see consultants for.
Yeah, it really is. I mean, and talking about exempt and non-exempt, not to get into it too detailed here, but we have so many things going on in the news right now with the Department of Labor salary changes and just real briefly, where do you think this is headed? Are they going to throw out this new rules of the salary changes that just got rolled out and just went into effect, as a matter of fact?
Well, who knows exactly what some judge in Texas might do. At this stage, every business owner and every HR person across America should be making sure that anyone that's not getting overtime better be making at least $844 a week, which is $43,888 a year. So if someone's making $40,000, $41,000, $42,000, $43,000, they're not going to be exempt. So that's a big deal. The numbers used to be a lot less. It used to be 35,000 and change for the year. It's gone up. And then it's supposed to go up again in January. I don't know if that one's going to kick in because there's a lot of time between now and then. The courts can do a lot of things. But as of right now, the Department of Labor is moving forward. They're considering, hey, this is what we're doing. This is what we're, enforcing. Plaintiffs' lawyers are starting to write demand letters, and they can be bringing in lawsuits. As of July 1st, that's what the requirement is. Obviously, the safest thing is just to pay everyone overtime, but that's not what you have to do if you can properly classify them, right?
Right.
You asked me about 3 things. We only got into one, and I know there are 2 other ones that you wanted me to talk about.
Hold on 1 second. JC has a question.
David, I came across a fantastic article. I need to share this with the listening audience. I'm going to give a summary, and then I'll also provide where this could be sourced and referenced, and then throw it over to you for a little comment, if that's quite fine. So it's stated here that Florida businesses, particularly in the bar and restaurant industry, frequently use a $3 2-cent tip credit against the state's 12-hour minimum wage for employees who receive tips. Now, that's $12 an hour in Florida. A little shocking if you're up in New York by me, where it's $16 an hour, but I digress. Now, under President Biden's Department of Labor, revised regulations permit this credit for both tip producing and directly supporting work, provided such supporting work doesn't exceed 20% of the work week or 30 continuous minutes. Employers must meticulously track employee time to ensure compliance, as exceeding these limits necessitates paying the full minimum wage. That, ladies and gentlemen, could be read at MiklasEmploymentLaw.com on the most recent blog Article entry, are you allowed to pay less than $12 an hour for a server who rolls silverware for 31 minutes? Break this one down for us if you could, David. Let's clue us in a little bit more on the details here.
Sure. And I see this a lot. I get a lot of demand letters. It's mainly in the hospitality industry, restaurants where servers or bartenders. This is where the employer chooses to take what's called a tip credit. This is where an employee receives enough tips that they can say, well, instead of paying the minimum wage, we're going to take the tip credit. And we know that the difference will be made up by tips. And there's a lot of things. Once you take that tip credit, you can't take any deductions because it's going to necessarily bring them below minimum wage. So if you give someone a uniform and you try and deduct that out of their pay, if you're taking the tip credit, boom, that's a FLSA violation according to the Department of Labor. Now, if you choose to pay them a little bit higher, then you can make that deduction so long as it does not bring them below minimum wage. And we see all this stuff in the hospitality industry because if someone's rolling silverware, let's just say they come in the restaurant for an hour before it's even open, and they're rolling silverware, filling up salt and pepper shakers. Well, for that hour, there's absolutely positively no way they can earn a tip. So that for that first hour, they should be making minimum wage. You don't get to take the tip credit during that hour. And that's the kind of stuff that these lawyers are suing businesses for. And they're picking, okay, well, for the first hour of every shift that these people work, and maybe even the last hour after the restaurant's closed, they can't earn a tip. Or maybe they're rolling silver more than 20% of that hour. So that 1 hour shouldn't be taking a tip credit. And once you mistake that tip credit, you lose the tip credit. So I mean, these can be very expensive, lawsuits against the business.
Wow. Yeah, that is definitely something that I think in my brain, I knew that, but I honestly, I don't work with restaurants. Not that I don't, but I rarely do because they usually can't afford to pay the bill. But I'd rather them pay you in advance so that they don't have to, chuck out money for a lawsuit. So thank you for that.
That really, if there's one take home message that I try and hammer into people's heads is a little bit of investment up front saves so much money later on. Because, for instance, if a restaurant, and I had a case where the restaurant got sued for $800,000. And if we had just had a brief thing, maybe about $1,000 worth of work, we could have got everything set up on the front end right. And they would have avoided all of that potential liability. But they kept doing it wrong for 2-3 years. And then they got caught, and they did this for 60 employees for the course of 2 years. And, that it just keeps adding up over and over. And once you get tagged for that, then you're also on the hook for liquidated damages, which basically doubles that. And if a lawyer caught you, then their lawyer is going to get their attorney's fees. Now, if the Department of Labor catches you, then they're going to go back and open up the book against all of your employees and all your former employees, not just one. So it's just a pound of prevention,
Yeah. So, talking about misclassifying employees, it's not just about the exempt salary or the non-exempt hourly. It's also about independent contractors, right?
Absolutely. And this is a big thing. One of the key things the Department of Labor does when they investigate a workplace is they look for two key things. One is there minors in the workplace, or there underage people working, and because there's a lot of restrictions on minors, and are there independent contractors? And frankly, it's because a lot of businesses misclassify workers as independent contractors, and they don't pay their share of, FICA and Social Security withholdings, and the government gets screwed out of the money. So they don't get the tax money. So they're really, looking for misclassified independent contractors. And it doesn't matter what the worker wants. It doesn't matter if the worker wants to be 1099. If you don't meet the test, then the burden's on the business to prove that they meet the test. And if you can't, then usually you're going to get tagged. You get tagged for unpaid overtime. You get tagged for unpaid withholdings, taxes. The Department of Revenue comes in and with their hand out, and they come back for all the back taxes. There's fines and penalties. Again, that's one of those things that can be completely avoided if you bring in, an expert at the beginning to kind of make sure you get set up right. And, they're like, well, shoot, Dave, I've been in business for 10 years. I didn't know that. Well, anytime is better than never doing it. Once you fix it, then at least moving forward, it's going to be fixed. And, like they say, the best time to plant a tree was 20 years ago, but next best time is right now.
Right.
I like that one. That's strong. I've got a material question for you on this one here. The independent contractor ruling here, that was what? That was March of 2024, I think it was, for the state of Florida law. So it's been stated that this rule potentially complicates the classification process, requiring a more comprehensive analysis of, quote, multiple factors increasing the likelihood of misclassification. Without going too deep, What does that even mean? What makes it that much more complicated now to help decipher this? And at what point should someone tap out and just say, you know what, let me call David Miklas or any other preferred labor attorney that might not be featured on our program that's actually pretty cool and drinks beer and is a good looking man like you?
So actually, and this is not a Florida thing. This is a federal law, the independent contractor thing. Basically, nothing really changed from an enforcement perspective. The Department of Labor really didn't care what the temporary Trump, rule was. The Department of Labor said, "Oh yeah, we're not going to follow that." And technically, it was in effect for a little bit of time, but they never really, at least in my area, they never really followed it anyway. They kept looking at the 6-factor test like they've been doing for years.
Yeah.
So as a reality, nothing has really changed from an enforcement perspective. Lawyers write articles all the time about what changed. It would have been good for business, to defend businesses and defend lawsuits if we were under the Trump, plan, because instead of a 6-factor test, it was a 5-factor test, which really put a lot of emphasis on 2. There's no point talking about that because it's not what's in effect right now. It's a 6-factor test, pretty much like it's been for many, many years. Anyone that has got legal counsel about this 5 years ago, if they got legal counsel on it, what the status is right now is probably the same as what it was back then. If they got counsel during the Trump years, it might be a little bit different. But at the end of the day, there is a 6-factor test. It's upon the business to meet that. And if they can't prove that they meet it, then the default setting is every worker is an employee and is entitled to, taxes getting taken out and is entitled to overtime if they work more than 40, unless you could prove that they're exempt or unless you could prove that they're an independent contractor.
Thank you. Thank you for clarifying that. Okay, so let's go on to the second common mistake businesses make that leads to costly lawsuits and probably destruction of their brand too.
Absolutely. This really deals with rejecting accommodation requests. And this falls into 3 buckets. If somebody is disabled, or if they are pregnant, which is not a disability, or if they have a religious accommodation request. Those are the 3 dangerous areas where, assuming that you're covered by the law, then you have an obligation as a business to engage in an interactive process with the employee to determine, is there a reasonable accommodation that can be provided to the employee to allow them to perform the essential functions of their job. And each law is a little bit different in the way that they look at this. But at the end of the day, you can't just say, yeah, we're going to fire you because you're pregnant or because what you're asking for is just too burdensome. The burden really is on the business to prove by actually looking at the numbers and crunching them and say, you know what, if we let you take Rosh Hashanah off, it's going to cost us $50,000 in overtime. Well, guess what? It probably is you're never going to be able to show that. So, the burden on the employer is almost never going to be met. Now, the smaller that the organization is, if you have 15 or 16 employees, the burden is probably going to be a lot more than if you had a much larger organization where you can have, more coverage because you have more employees that can kind of swap shifts. And that really comes down to it. Pretty much it's up to the managers to find people for coverage. If, some people want days off for Rosh Hashanah, or if a pregnant lady needs to come in late because she has morning sickness, things like that, once your business grows and you're covered by these laws, that's the kind of thing that ends up being a cost of doing business.
Specific to the interactive process, though, David, like when we think about it from the employer perspective, the documentation burden that they might be under, or cost and resource allocation through the interactive process, and making sure that everything is properly, meticulously, and carefully crafted and documented and followed along. At some point, an employer really can't navigate that solely on their own, could they? Or would it be advisable just to generally seek at least some guidance on this before trying to head down that path alone?
So if someone's listening to the show right now, they're like, oh my gosh, we haven't been doing that, then I would certainly encourage them to immediately contact an HR consultant or an employment lawyer for guidance. But as a reality is, a lot of businesses may already have forms that they've put together as part of that interactive process. I'm a lawyer. I love everything documented. I love everything in writing. The law doesn't necessarily require certain forms, but it's the employer's burden to prove that they've done this. Now, in my practice, my law practice, I actually will ask my clients, do you have text messages? Do you have Slack? Do you have anything at all that you can show me that you engage in this interactive process? Now, in a perfect world, we'll have 5 emails going back and forth. Sorry, Susie, we can't give you the $15,000 chair you asked for, but we went to Walmart, or we can go to Walmart, and this looks like just like the same thing you're asking for. It only costs $300. Will this be good enough? And that's what it is. It's back and forth. And ideally, the employer will have documented it somehow. And I think of this like a hot potato. Mm-hmm. You throw the hot potato back and forth. Whoever at the end of the day is still holding that hot potato and doesn't give it back to the other side, they generally lose. So in a perfect world, if an employee asks for an accommodation and if the business can give it, great. They've done what their obligation is. Sometimes you can't. That interactive process means that the business says, hey, you know what? We can't really do that, but how about this? So that's throwing that hot potato back to the employee. Either they're going to accept it or reject it or try and negotiate something. So it tends to go back and forth sometimes. And sometimes it may land in someone's hand for a while, and then maybe things change, like the dog. If someone says, hey, I want to bring in a service animal. Okay, maybe you give that a try. Maybe it works for a while, but maybe all of a sudden you have an employee who's allergic or scared of dogs, and maybe it won't work anymore. And then, okay, sorry, we tried it. It didn't work. The dog pooped on the floor, whatever it is. But, maybe there's something else we could do. Maybe you can go on Prozac, or, maybe there's some other kind of accommodation that can still allow you to do your job, get through this anxiety or PTSD or whatever it is that you had that dog for. And that's what the interactive process is. And when it comes to the pregnant women, there's a new law came out last summer, the Pregnant Worker Fairness Act. And this is really a new thing where you need to be really careful before you say no to a pregnant woman who's asking for accommodations. And some of these are just very basic accommodations, like asking for a water bottle, to sit down 5 minutes every hour for a break to get off her feet, things like that really should be no-brainers. But so many managers screw this up. It's not HR, it's not the business owner usually. Sometimes it is if they have a God complex, but a lot of times it's just a manager trying to show that they have the power and they can say no. And that really, creates legal
and then they're creating inconsistent measures, and then the perception is off and skewed, and it's viewed as not consistent. And even if you are being consistent, if that perception is skewed, you could just be facing legal challenges. I'm not saying you will by any stretch of the imagination, but perception's reality in many of these instances, right? Or am I wrong there?
Right. And this is why I'm a big fan of, if you have human resources, that they are typically involved in any kind of medical issues or any kind of discipline issues. And it's not to micromanage the managers. It's to make sure that managers in different departments are treating people consistently across the entire organization.
Yes.
That's how I view it. And when I come in and give training to managers, I let them know, listen, HR is really not here to make your life hard and to micromanage you. It's here to protect, to make sure that the whole organization is being fair to everyone, so that in Department A, you don't get 10 absences. In Department B, they really follow the rules strictly, and they write you up after 3. We want to make sure everyone is getting treated the same across the whole organization.
I think this brings us to our third common mistake that businesses make that can lead to costly lawsuits. And honestly, not just lawsuits, just turnover or lack of attraction of candidates because they've already heard about your yucky environment. And what is that?
My view, it's typically untrained managers. I don't typically see managers that want to be awful human beings. Occasionally that's there, but usually it's that they've been promoted and, maybe they've worked the line for many years. They've been great on the line. And then all of a sudden they get promoted to a manager position, but they're never really given the tools on how to manage employees, how to interact with employees, how to get the best out of them and be a leader. And when necessary, discipline or at least give feedback in a positive, constructive way. And that really creates the problem where these managers create costly mistakes. I can't tell you how many times I walk around a workplace and I see great documents on the wall that HR circulated. We got the posters, all the employment law posters on the wall. We may have a schedule on the wall, but then the manager takes a Sharpie and writes, anyone working beyond their schedule will not get paid for it. Well, guess what? You take a picture of that, and that's Exhibit A in the lawsuit for unpaid wages. It doesn't matter what's on the schedule. You have to pay the employees, the hourly workers, for all hours that they actually worked. So that manager, by writing that on there, by putting their foot down, trying to say, hey, we're not going to work overtime here, the way they did it actually would create legal liability in that example that I gave you. And that's the kind of stuff where if you give the managers training and show them some of these areas to be careful about, then they realize as part of the organization where their role is and when to pick up the phone and call HR, call their boss to make sure that they're doing it right, running something by their boss before they just kind of wing something out there, especially with discipline. I don't know how many times I've seen a manager fired off an email or a text message saying, consider this your write-up for talking about wages. Well, guess what? That's illegal under the National Labor Relations Act. You cannot discipline an employee for talking about wages.
Exactly.
So some of that's low-hanging fruit. And you go to even a basic, Employment Law 101 basic webinar, the manager can learn that kind of stuff. Or at least, even if they don't remember it, they at least think, you know what? I remember something about this being dangerous. Let me call my boss. Let me call HR just to make sure I'm not, stepping in it.
You said it best. They could be an amazing line worker. They hop into that role, and now it's the next thing's out the door. What is the FLSA? Their arms are up in the air. They don't even know. The Department of Labor is going to frequently audit companies for compliance, and violations can very frequently result in substantial fines and compensation orders, from wage and hour law issues, employee misclassification, record-keeping requirements, penalties and fines, back pay, class action lawsuits, reputational damage to your organization at the end of the day. If the manager isn't effectively trained and brought up to speed, not to say that they need to be an expert. I'm not saying it, but I'm going to float it out there that they need to be. But David, you tell me that they don't need to be. Okay. But please, honestly, if they're not an expert, that's fine. As long as they're aware there's a flag on that item and they know who to go talk to. Right. Is that good advice, Wendy? David, talk to me, please. Reassure me.
Yeah, I mean, I think David and I are on the same page. We both do management training, and it just depends on the organization. If you're in a small business where you only have like 10 employees, the manager probably is HR as well. So they need to know a lot more about the laws and the forms and all of this stuff. Or, maybe they have an HR consultant or employment attorney. If they're in a very large organization with a big HR department, maybe they don't need to know the very specifics of, the Pregnant Workers Fairness Act, but they need to know those ding, ding, ding. I can't say this. I can't do this. And this is the reason why, not just because it's a law, but because it's going to cost us a lot of money. Coming back to where David started this session off today, talking about prevention is always an investment, and inexperienced financial leaders tend to see the world in cost, in money. And so, a court claim, or even if it doesn't go to court, it just goes to another attorney, right, David? That's going to cost the company money. So let's use the money in preventing and training your managers. I even say, David, down to the receptionist who's greeting candidates when they come in. Like, okay, you can't say something about their headgear that might be religious, or the fact that they're pregnant, or that they have a disability. Like, you have to train everybody who, for lack of better word, touches the candidate and the employee. Please don't touch your candidates. Please don't touch your employees.
Oh, gosh.
And that got me thinking. We talked a lot about the FLSA and the Department of Labor, but the EEOC comes in nicely here. I think that it's helpful, for instance, if you ever receive an EEOC charge of discrimination, as part of the response, I think it's helpful to tell the government that you take this stuff seriously. You've trained your staff 3 months ago on this. Ideally, there'll be multiple trainings that the person underwent. Ideally, you'd have some live interactive training, Wendy, like the type you and I give. And I tell my clients the very first investment a business should make is to get an employee handbook that's not just generic downloaded off the internet. The second investment I tell my clients to do is to do training. And that's why, a lot of people, I know Wendy has it, I have it, some kind of packages that encourage businesses to do these two key things, handbooks and training, because it really is the foundation for, preventing lawsuits. And if you can't prevent them, then at least to help defend against them.
Yeah, I absolutely love it. Hey, David, where can our listeners find you to maybe stalk you and learn more?
Sure. Probably on LinkedIn. I post almost every day on LinkedIn.
Yeah, you do.
And they don't even have to connect with me. I'm near my cap. So if they just follow me, then they'll see my stuff in their feed. I post regularly. Some of the stuff is just outrageous, crazy things that are going on. And, people get my newsletter once a month. Well, there's maybe 4 or 5 articles in there. Otherwise, on LinkedIn, I'm posting stuff 4, 5, 6 times a week.
Yes, I absolutely love your posts. They're so real and so realistic. And I think in the olden days of HR, we weren't taught this stuff. We were just taught things by the book. And when you get into HR, you go, oh, nothing happens by the book. So folks that are listening, please, follow David Miklas on LinkedIn. I'll make sure his information is in the podcast description. And to our listeners, if you're interested in being a guest on a future episode episode of the HR Lady, or if you want a certain topic, just let me know. Visit thehrlady.com to get in touch. And I also wanted to let you know that I will be releasing very soon, in a couple weeks, Insider Access membership-based program. And it's going to be very direct, like me, and very, very affordable. And I just doing this so that I can help everybody in the best way that I can. And David also has similar services. So with that said, any final words, David or JC?
No, thank you all for letting me get on my soapbox, and hopefully we can catch some ears and prevent some lawsuits.
Yeah, absolutely. Thanks so much. Take care, everybody. Thanks for joining us.